My name is Harry, and I'm from London.
Meghan Markle here.
All right, today is March 13th, 2024. It is 12:06 a.m. All right, so I have some stuff to share with you, but I think I'm just gonna do one video. This is what I was starting to gather during the week, during the day. And then once I came from the gym, and then I saw that about the lawsuit. Meghan won the lawsuit. So I was like, oh, I need to look more into it. So there are some tweets regarding the lawsuit, but I think, okay, so this will be one video. There's Omid talking about it, some Sussex squad talking about it, there's Buzzy talking about it, so I wanted to share this with you. But I think this is going to be one video by itself because I have the link to the court documents. I have it open already. And I want to look into it and see what was said. Because I remember the last time I talked about it. And I said, I think the judge wants to give the sister as many chances as possible to make sure. Because I already knew Meghan won the case because the sister couldn't really prove anything. And I saw the interview, the Oprah interview. I didn't see any defamation. And I was like, you know what? I think the judge wants to make sure that when she get her judgment, nobody gives any like second thought or something like that. You know, she wants to make sure that the sister looked very carefully. I think the second time, the last time I talk about it, the judge sent her to go look deeper and to prove her case, because before she wasn't really proving her case. So now that the judgment came, and it's not a surprise. Okay, so that is probably gonna be one video by itself, depend on how I feel after I read. I think there's like 50 something pages. Depending on how I feel after this, then maybe I'll look into this and share with you. Other than that, it will be for another day. And these are the noisemakers and the left behinders. If the lawsuit then come, I'll be doing this. So I'm not gonna delete these for now, but let me not waste time. This is the background. Feel free to skip. All right, so this is the background. 3,834 subscribers, new subscribers welcome. Estimate 157.55. And that was the last video I made public. Analytics. Okay, so there's the numbers here. Estimate 157.55. And the last 48 hours, I had 1,760 views. And there's the subscribers. So let's go on Twitter. This is where I sort of got the link from one of the squad. Okay, so it says here, the entire case file is huge, but thanks to the legal slur within our squad. Here are the two most important pages. However, you can read the other pages if you want to see Sammy get a smackdown. Okay, so I'm gonna read this completely, so let me just read some of the, you know what, let's just go to it and I'll come back to Twitter. All right, so there's the pages here. How many pages? 58 pages, and some of them are short. This is the last page, so let's start from the top. Okay, there's the name here. Samantha Markle, plaintiff, versus Meghan Markle. There's the case number here. Order. This cause comes before the court upon defendant Meghan Markle's motion to dismiss the third amended complaint and incorporate memorandum of law, docket 74, plaintiff Samantha M. Markle's response and opposition, docket 79, and the respective reply and reply dockets. There's all of this. I guess for formality, they have to mention all of this. For the reasons set forth, the court will grant the motion to dismiss. Moreover, because amended will be futile, plaintiff claims will be dismissed with prejudice. Okay, one. And I think in my community board, I looked the word prejudice, with prejudice, and the meaning was there. All right, so there's this here. Factual background. This motion addresses the third iteration of plaintiff's complaint in which she brings one count of defamation and one count of defamation by implication. See that there's all of this. Okay, the court granted defendant's motion to dismiss the first amended complaint. See docket. I probably have recorded these already. These documents that she's mentioned. Okay, plaintiff defamation claim based on Finding Freedom, a book published by a third party, were dismissed with prejudice because 1. The court has also considered the supplemental authorities provided. Okay, so I'm not going to go to each one of this, then it'll be forever. All right, so there's documents 94 and 101. Okay, defendant did not publish the relevant statement and therefore could not be held liable for them. Okay, so in other words, this case, okay, plaintiff Samantha Markle, defendant Meghan Markle. So Meghan was asked the judge to dismiss the case, and there was a whole bunch of reasons why the case should be dismissed. So what the judge is saying here, Finding Freedom, which everybody knew, Meghan did not write it, and they're blaming Meghan for whatever information that was in Finding Freedom. Okay, so that's that. And let's not forget as well, this we need to take into consideration. When Meghan was a working world in the UK, is it Jason Kanoff? Yes, Jason Kanoff was Meghan's assistant, communication secretary. So Meghan had sent Jason Kanoff a text message. She wanted to speak to him in regard to Omid. It seems like Omid had sent her some question to respond. Okay? Because at that time, Omid was gathering his information to put in the book, Finding Freedom. Okay? So, in my humble opinion, Meghan must have given Jason Kanoff the answers for the Finding Freedom. Now, this is where things get mixed up in transition. There's a possibility, in my humble opinion, once Meghan gave Jason the response to Omid, there's someone intercepted and then switch some information and gave it back to Jason Kanoff to give to Omid. So which means Omid probably, in my humble opinion again, did not get the correct information from Jason because someone intercepted it and switched the answers around, and then we got those in the book. Okay, so it's not Omid's fault and it's not Meghan's fault. Whose fault it is? Guess who? The one that Meghan gave the response to, in my humble opinion. And then from there, if they decided to go deeper into that and ask why this answer did not correspond to what Meghan said, then it's up to him to say who made him do what he did. Because apparently, from what I've Meghan and Harry was not his boss. Okay? They assigned him to work for or to help Meghan and Harry. Okay? And then we know the whole bunch of other stories that happen. Okay? So that's that. And as I said this, I hope you were looking at the screen, because most likely when I'm editing, I'll be putting those emails and information. All right? So let's continue. So that's this here. Defendant did not publish the relevant statements and therefore could not be held liable for them. Okay, Meghan did not write the book, so don't blame her for that. Okay, the court dismissed defamation claim based on 3 statements from a televised interview without prejudice, based in part on plaintiff mischaracterizations of the transcript. Okay, so they turn it into whatever they want. At 17 through 23, the author further noted that defendants' substantive arguments regarding these claims appear to have merit. Count 2, a claim for injurious falsehood, was dismissed without prejudice under Florida's single action rule, which hold that a plaintiff generally may not allege multiple causes of action based on the same defamatory publication or event. At 25 to 27, plaintiff has not repleted the injurious falsehood claim. Okay, injurious falsehood claim. I'm sorry with my accent, okay? And the operative complaint, plaintiff reassert her defamation claim and adds a defamatory by implication claim based on the television interview documents. There's the numbers here. Okay. She also asserts new defamation and defamation by implication claim based on a statement from Harry and Meghan, a Netflix documentary series released in December 2022. Okay, the parties and background allegation. So the judge is gonna explain. I guess, okay, I'm not into the legal business. This is my disclaimer. I should have said that from the beginning. I, by any chance or no way, I'm not a lawyer. I'm not into the legal aspect. I'm just reading what's there and then give you my humble opinion. That's it. Okay? The only thing that I've studied in college is architecture. Okay? That has nothing to do with law. So this is my disclaimer. So if you're reading along, you just want to hear my perspective on things, and obviously the link of this will be in the description. You could easily skip completely the video and go straight to the documents and read yourself. Okay? So it seems like the judge is explaining here her understanding of what was represented to her. This is what I think here. All right. The parties and background allegations. Samantha M. Markle, plaintiff, is a citizen of Florida and half-sister to Meghan Markle, also known as Meghan, the Duchess of Sussex, defendant. Okay. The two were close during childhood, and plaintiff regularly drove defendant to school and helped her with homework. Okay. So the judge is saying, since they were kids, okay, there's Meghan, who is the half-sister, and she's also known as the Duchess of Sussex. So when they were kids, this is what Samantha used to do. Drove her to school and helped her with her homework. Okay? They had a good to wonderful relationship. As defendant achieved success as an actress, she no longer had time for plaintiff, and the two stopped visiting by 2016. Then once defendant met Prince Harry and became engaged to him, the half-sister became estranged. Okay, so that was the complaint, that when Meghan became very successful as an actress and now marry Harry, all of a sudden, that's what she made the court seems. Okay, no longer speak to her anymore. Let's not forget, Samantha been going on TV in the UK and Australia saying some BS stuff, and then on Twitter as well. I don't follow her, but I've seen some screenshot. Okay, so let's continue. In 2017 and 2018, defendant hung up on plaintiff during a phone call, and ultimately of her family members only invited her mother to the royal wedding. Okay, which is Miss Doria. Plaintiff was subsequently discovered by the media and in an interview stated that defendant had not contacted their father after he suffered 2 heart attacks. I talk about this in some old videos on PYTE, so whatever. Okay, the press used fabricated quotes and wrote the plaintiff bashed defendant. She put it in quote, bashed defendant. Subsequently, defendant allegedly started a smear campaign against plaintiff and began to resent her. Okay, the CBS interview on March 7, 2021, Oprah Winfrey interviewed defendant and Prince Harry on a televised CBS special. Approximately 50 million people tuned in. Plaintiff alleged that defendant made 4 defamatory statements in that interview. The court has already taken judicial notice of an undisputed transcript of the relevant portion of the interview reproduced below. Okay, so in other words, I believe on my last video that I discussed this, the judge had already reviewed that, and I think she dismissed it. Okay, so she's putting some quote here from the interview. Okay, I'm not even gonna go to it. Okay, you could just go and watch the interview. All right, it's from page, where was it? Page 3. Okay, speaker, she found out her dad was working with the tabloid. Okay, from page 3 all the way to page 6. All right, so she quote from the interview. So she quote that, how would I say that? The judge. So let's continue. Beginning in December 2022, the streaming platform Netflix released a 6-part miniseries entitled Harry and Meghan, the series. There's documents 72. The series, a joint effort between defendant's production company and another entity, was filmed, edited, and produced for Netflix under the direction of defendant and Prince Harry. It consisted of 6 episodes, each spanned around an hour, and featured interviews with defendant, Prince Harry, and friends, family, and interested and participatory parties. The series directly or indirectly referenced plaintiff in 4 episodes. 45. Plaintiff alleged that 14 statements from the series were defamatory, included numerous statements by Christopher Buzzi, a non-party to the suit. No wonder why Buzzi, I actually just spotted here. Buzzi was, there's a tweet that I have regarding Buzzi. Maybe I'll put it at the end of this video when I go back to the Twitter. Okay. Plaintiff live in Lakeland, Florida, where she is well known for her ties to defendant. As a result of the defamatory statement, defendant's fan base, including a significant part of Lakeland's population, became angry with plaintiff and turned against her. So she's blaming, what is it? The interview, the docuseries, the Netflix docuseries on Meghan, because some of the things Meghan have said, now her neighbors or whatever popular in Florida, are turning against her. But she forgot what she did in the UK. She was talking some nonsense in UK and in Australia. What is it? In one episode where I have one video clip I have where they said we need to bring her and discuss it, and the presenter was like, I'm not gonna pay her to come and do an interview.
True, because remember, I know that was set up pack shots, but remember he was filmed, the dad, getting measured for the suit, reading up about England. So if he wasn't invited, that doesn't even make sense. And I know the paps set him up with that, but that was on the pretense that he was going to the wedding. So what she's saying doesn't add up.
Well, why don't we get her on next week? For interview.
We are not paying her $200 for an interview.
Alright, so that's that. Let's continue with this. Plaintiff became known as an opportunist trying to cash in on her sister's success and fame despite having no relationship with her. The defamatory statement caused prejudice, injury, and harm to plaintiff's reputation, as well as anxiety and emotional distress. I don't know. In my humble opinion, she bring that to herself for going on TV and do all of that. And then travel to the UK trying to... I feel embarrassed for her trying to get into the palace. My goodness. Meanwhile, Meghan was going through her own stuff. Alright. She received hate mail, ongoing negative press, and was stalked. I don't know. Moreover, plaintiff has been unable to work as a mental health counselor due to the reputational damage. I'm gonna leave it as that. Okay, judicial notice. The court heard our argument on this motion on November 8, 2023, documents 110, at the proceeding. Plaintiff counsel indicated that plaintiff did not oppose any portion of defendant's request for judicial notice in support of the motion to dismiss. Okay, thus the court takes judicial notice: A, the provided transcript and footage of the Netflix series, the existence of previous media report regarding certain claims in the series, and C, the transcript of CBS interview at issue and the first amended complaint, and again here. All right, so they included here. I'm not gonna read that. The court has reviewed these exhibits in full, including both the transcript and footage of episode 5, which was provided on a flash drive because certain visual elements of the episode could not be transcribed. Okay, there's that here. Legal standard. To survive a motion to dismiss under Federal Rule of Civil Procedures, okay, maybe this I could look. All right, this had nothing to do with. All right, let me search that. Fast forward. What is this? Federal Rules Civil Procedure 12B6 authorized dismissal of a complaint for failure to state a claim upon which relief can be granted. The complaint must be liberally construed in the plaintiff's favor, and all facts pleaded in the complaint must be taken as true. See compile, there's that here. So that's what this means. Right, oops, where is it? Not that. Okay, so that's why. To survive a motion to dismiss under federal rule, okay, so this has to be true, so for the court to agree with it. All right, a pleaded must be included a quote short and plain statement of the claim showing that the pleader is entitled to relief. Okay, so there's all of this. What is that now? Now I'm curious. Let's look at this. Ashtroff, okay. When considering a motion to dismiss for failing to state a claim, a court should accept the fact pleaded in the complaint as true unless, okay, the Supreme Court held that with this whatever complaint failed to plead sufficient fact to state a complaint for purposeful and unlawful discrimination. The court affirmed that the Second Circuit had subject matter jurisdiction to affirm the district court order denying petitioner's motion to dismiss. Okay, so go back to this. All right, so there's a whole bunch of other things. If I keep on reading each one of them, I'm gonna be here forever. Labels, conclusion, and formulaic recitations of the elements of a cause of action are insufficient. Okay, mere naked assertion are also insufficient. A complaint must contain sufficient factual matter which, if accepted as true, will state a claim to relief that is possible on its face. So the judge is explaining how a defamation, this defamation case can be won, and went back to some other lawsuit that had happened in terms of, I think they call it precedent, things that had happened. She could base it on that. So she's just listing how this case, the defamation case, can be won. Okay, so we know she lost, so which means she didn't prove her case based on these facts. These already made these courts that have already won based on defamation. That's what I'm getting from it. In my humble opinion, a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconducted alleged, okay, internal citation omitted. Okay, the court is not bound to accept as true a legal conclusion state as a factual allegation in the complaint. There's that. Overall, the complaint must give the defendant fair notice of what the claim is and the ground upon in which it rests. Okay, so there's all of that. Okay, and ruling on a motion to dismiss, a court is generally limited to review what is within the four corners of the complaint. Austin versus that. These are other lawsuits she's making her reference to. However, it may also consider attachment or exhibit provided with the complaint. There's another case here. Where is that? Civil rule provided that attachment to a complaint generally becomes part of the pleading for all purpose. There's another that. Okay, including for ruling on a motion to dismiss. These are other things the judge can make reference to for her final decision. Okay, a district court can also take judicial notice of a adjudicative fact that is, quote, not subject to reasonable dispute and either generally known within the trial court's territorial jurisdiction or 2, capable of being accurately and readily determined from sources whose accuracy cannot reasonably be questioned. There's another dot here. Discussion. Okay, there's a lot here. I'm only on page 9. Plaintiff's third amended complaint brings just 2 claims, defamation and defamation by implication. Nevertheless, the 18th statement on which those 2 claims rely present a plethora of issues. Ultimately, the court finds that plaintiff fails to plausibly state a claim for defamation or defamation by implication as to any of the statement. So in other words, she just didn't prove her case. Samantha, that is. Okay. As to the defamation claim, each and every statement is a non-actionable either because it is protected opinion. Okay. Meghan was giving her opinion. Substantially true based on judicially noticed evidence not capable of being considered defamatory, or because plaintiffs precluded from meeting the actual malice standard because the statement in question was presented together with plaintiff's version of event. So in other words, Meghan said her opinion, how she sees the thing, and then Samantha sees it in her way. And the court said, I cannot blame her. Okay? I cannot blame Meghan for not seeing it the same way that you see it. This kind of thing. That's my interpretation of it. Therefore, the defamation claims in count 1 based on the CBS interview and the Netflix series will be dismissed with prejudice. What was that again? Dismissed with prejudice. I already forgot what that means. I think completely cannot bring. Okay, when a court dismisses an action, they can either do so with prejudice or without prejudice. Dismiss with prejudice means the plaintiff cannot refile the same claim again in the court. Okay, so she's done with. She cannot bring that case again, like a double jeopardy kind of thing. So the judge dismissed that completely. Okay, and this is the part where before I think the judge gave her dismiss with without prejudice or something, without prejudice where they could bring it back. So the judge had given her second chance. When I look it up, and I was like, oh, she's probably giving her a second chance to prove herself, because in the first place there was no ground for what she was saying here, okay, for her complaint. So now the judge is dismiss it completely. Samantha cannot bring that nonsense again to court. Okay. As to count 2, plaintiff's own allegation contradict the element of her claim. She repeatedly asserts that each defendant's relevant statement is false, but defamation by implication claim requires plaintiff to identify statements that are true, but create a false implication. Oh my God, she creates something out of in her own head, and then she expects the court to agree with that, and the court is saying no, that's not what she said. Oh my goodness. Let's continue. Moreover, as the protection of defamation law extends to defamation by implication claims, and the court has determined that each statement is a non-actionable, plaintiff claims in court 2 are deficient twice over. Moreover, plaintiff fails to plausibly plead actual malice. Okay, she didn't prove her case pretty much. Therefore, as described below, plaintiff cannot state a claim for defamation by implication, and amendment will be futile. Okay, defamation. The substantive law of Florida applies to plaintiff defamation claims. Okay, so there's all of that. That's the meaning under the Florida law, how they could, how they view defamation. You know what? Let's look it up just for the sake of it. Turner versus that. All right. Under the Florida law. Let's leave this open just in case I want to come back to it, because sometimes I question myself. Turner versus Well. Okay. Wasn't it judge for the United States Court of International Trade sitting by... Okay, so there's a whole bunch. I thought I was going to look straight into it. Oh, what is that? Okay, so this is the case here. So forget it. I'm not going to go into that. Okay, defamation comes in one of 2 forms. Libel, express in print, or slander, spoken or oral defamation. Okay, so she's giving... This is 2 ways a defamation can be done. 1, print on the paper, or you say it somewhere, probably on TV or whatever. All right, so let's continue. These are other cases where she's making reference to. Either type of defamation consists of the same element: 1, publication; 2, falsity, okay, that the actor acted with knowledge or reckless disregard as to the falsity of the publication on a matter concerning a public official, also known actual malice. Okay, so this is the meaning of it. This is how, if for instance Samantha were to win her case, that's if Meghan have done all of this. Meghan was fully aware what she was talking about and purposefully and slander her. Okay, but Meghan did not do that. She was giving her opinion. But anyway, or at least negligently on a matter concerning a private person. 4, actually damages. And 5, that the statement was defamatory. Jews, there's all of this. Okay, that's another case. As to the third element, plaintiff counsel agree at oral argument that plaintiff must allege actual malice because defendant is a public figure for purposes of this lawsuit. Okay, as the complaint suggests, there's that here. Therefore, to survive a rule, this, I think that's the one I look. Rule, let's look at this. Alright, this one I can find the director of it. Let's just go. Okay, Rule 12b6 permitted a motion to dismiss for failure of the complaint to state a claim in which relief can be granted. She's gonna have to pay. Is substantially the same as the old demurrer for failure of a pleading to state a cause of action. Okay, so that's what that means here. Go back to this. Challenge plaintiff must possibly allege that defendant made each defamatory statement with knowledge that it was false or reckless disregard of whether it was false or not. Okay, so there's another case making reference to that. A statement is defamatory if it tends to harm the reputation of another by lowering him or her and the estimation of the community, or more broadly stated, expose a plaintiff to hatred, ridicule, or contempt, or injure his business or reputation or occupation. So there's the case making reference to that. True statements that are not readily capable of being proven false, and statement of pure opinion, however, are protected from defamation action by the First Amendment. Okay, so in other words, when someone gives their opinion, you cannot blame them for that. Okay, for whatever defamatory, just an opinion. Whether a statement is one of the fact or opinion, and whether a statement of fact is susceptible to defamatory interpretation or questions of law for the court. Okay, so there's another case here. All of this she's making reference to. And answering the two questions, the court must construe statement in their totality. So the court has to look into everything, every possible ways to come to a conclusion, with attention given to any cautionary terms used by the publisher and qualifying the statement. There's that here. This is the CBS interview here. Plaintiff's first 4 defamation claims draw from defendant televised interview with Oprah Winfrey. Okay, so in other words, what's her name? The half-sister. Part of her claim was from the CBS interview here. There's the thing here. You guys could go and look into it yourself. I'm not going to read it, or watch the interview again. Alright, so let's continue. Plaintiff avert that these disparaging, hurtful, and false statements insinuate she is a stranger, a liar, and a deceptive, fame-seeking imposter with avaricious intention toward defendant. Defendant argues that, alright, let me read this part here. Whatever's on that page from the CBS interview. Statement 3, defendant. The last time I saw her must have been at least 18, 19 years ago, and before that, 10 years before that. The 4th statement is as follows. Oprah Winfrey. So you all weren't close? You didn't grow up together? Defendant, no. Oprah Winfrey, she doesn't really know you. Statement 4, defendant, no. She changed her last name. This is what Meghan said. She changed her last name back to Markle, and I think she's in her early 50s at that time, only when I started dating Harry, and so I think says enough. Okay, so this is where she is making reference here. Deceptive, fame-seeking imposter for a vicious intention toward defendant. All right, so let's see what the court say about that. Defendant argues that none of the statement are actionable. There's was it document whatever to statement 1 and 2. She argues that they are unfalsifiable opinion and substantially identical to claims that were previously dismissed as opinion, okay, of her own childhood. Okay, so this is Meghan's own recollection. This is where recollection may varies. Okay, defendant argue is like as if was it the half sisters forcing the judge to see these things in her own way, and the judge said, I cannot blame Meghan. This is her recollection. This is the way she saw it as her childhood, from when the last time she remembered. All right, she didn't even give a specific, a definite time. She said, what is it, 18 or 19 years ago. All right, so it's not really a specific. It's even, recollection may vary. All right. At 6, okay, defendant argues that plaintiff fails to allege falsity as to statement 3 and again mischaracterizes the transcript and trying to rescue her claim as to this statement. Finally, defendant argues that statement 4 is substantially true and thereby incapable of supporting a claim. In response, plaintiff proceeded, oh my God, this is long. Yeah, I knew that. In response, plaintiff concedes that the first 2 statements may be opinion and the third is incorrect only as to the amount of time that lapses between visit. Okay, however, plaintiff assert that the statement combined with the 4th most damaged comment regarding her use of surname Markle sufficiently state a claim. There's that. Further, the plaintiff maintained that the statement can be proven. She also argues that the substantial truth doctrine does not apply because defendant stated her opinion based on facts not disclosed. Okay, and the statement were thus mixed opinion rather than pure opinion. Lastly, plaintiff emphasizes the millions of viewers worldwide that watch the Oprah interview and argues without citation to authorities or further explanation that libel by implication is obvious based on the audience to which defendant made the statement. Oh my God. Defendant replies that the substantial truth doctrine does apply, that the statement were not mixed opinion, and that all the interview claims should be dismissed. Okay, the court considered each statement individually, drawing all reasonable inferences in favor of plaintiff. Before doing so, however, the court notes that several allegations, in particular those related to falsity, immediately suggest that plaintiff disagrees with defendant's opinion rather than statement of fact. Okay, so just going by opinion. So the court cannot blame her for that, meaning Meghan. For example, plaintiff alleged that the statement painted her as a stranger, a liar, and a deceptive fame-seeking imposter with avaricious intention. There's that. She goes on to argue that the statement insinuates that plaintiff has concocted a fictitious story to reap some inappropriate reward from defendant's fame. These and other allegations discussed below are quintessential example of opinion that cannot be verified and therefore cannot serve as the basis of a defamation action. Okay, so pretty much Meghan was talking based on her opinion, but the other one is claiming that it's fact. For the reason that follow, each statement is protected from suit either as pure opinion because it is substantially true based on judicially noticed materials or based on plaintiff's failure to plausibly allege that they are defamatory in the first place. Okay, so she gave that here. I'll read that. Oprah Winfrey and Samantha Markle, your half-sister on your father's side, has written a supposedly tell-all book about you. What is your relationship with her? Defendant, which is Meghan, I think it'd be very hard to tell all when you don't know me. And it's this a very different situation than my dad, right? When you talk about betrayal, betrayal comes from someone that you have a relationship with, right? I don't feel comfortable talking about people that I really don't know. Even that alone already tells you. She didn't even go in full detail about it. Plaintiff assert that this statement attacked the veracity of her recently written and released book, and insinuating that plaintiff had concocted a fictitious story to reap some inappropriate reward from defendant's fame. Defendant argues that the court already found that a similar statement about her childhood and family was not objectively verifiable or subject to empirical proof, and therefore was protected opinion. Okay, betrayal is even more obviously a matter of opinion, and cite authority from within and outside the 11th Circuit supporting this argument. Plaintiff responds that defendant implies that okay, just because she said this is what she's saying here, because she said it, this is what she meant by what she said. Meanwhile, everybody heard what Meghan said. Right, you could make your own conclusion out of it. Implies that the plaintiff responded that the defendant, which is Meghan, implied that the plaintiff did not know her, and combined with the other statement aimed to portray her as an unwelcome opportunist, weaseling her way into the life of her half-sister who did not even know who she was. Okay, statement that cannot reasonably be interpreted as stating actual fact about an individual, cannot support a cause of action. All right, so there's all of that. Okay, while pure opinion or protected mixed expressions of opinion or not. Okay, so there's all of this. Okay, the test for determining whether statement or protected opinion is whether they are capable of being proved false. Okay, so you cannot prove that, so there's that. There's all of this again, another case. Opinions with no provably false connotation cannot support a defamation claim. There's all of that. Okay, so she didn't prove her case pretty much. Okay, did what Meghan said and you claim it's defamation, what case, precedent or something like that? She didn't prove it. These are full opinion. The court agrees that this first statement is, in the context of the interview, an opinion. Okay, so this is the court here. This is the judge saying here, I agree this is an opinion, which plaintiff essentially concedes, stating that, there's that, yes, the first two statements on their own may be opinion. First, the statement must be considered from the perspective of a reasonable viewer. There's all of that. In that light, the court can only conclude that the defendant's statement is an opinion about her childhood and relationship with plaintiff. As the court noted in its prior order, defendant went so far as to qualify her statement with the word really, to make clear that she was not suggesting she did not know who the plaintiff was, as plaintiff implies. There's that. Thus, as a reasonable listener will understand it, considering the qualifying terms and defendant's statement, she is merely opining that she did not have a close relationship with plaintiff. Okay, what it means to be close, to share a relationship with someone so intimate that you really know that person is a subject that might make a good father for philosophical, psychological, or personal exploration. So in other words, this type of thing here, whatever Meghan had said, it's not the judge kind of parameter. The judge cannot go deep into Meghan's brain to see what Meghan was trying to say, kind of thing. That's the way that I see it. All right. However, it is not capable of being definitely answering. Plaintiff cannot objectively prove that she really knows defendant, or that defendant falsely felt that their relationship was not sufficiently intimate to justify use of word betrayal. Because this statement is an opinion not readily capable of being proven. It is protected by law from defamation action. There's that here. All right. Moreover, defendant is correct that the judge agree with Meghan here. Moreover, defendant is correct that the concept of betrayal will typically be a matter of opinion, as other courts have found. Okay, so there's all of that here. Not only is the concept of betrayal on opinion, but defendant specifically states that she does not perceive herself as close enough to plaintiff to even feel betrayed by her, which there is no way to verify, making the statement a protected opinion. The claim is dismissed as the statement constitutes protected opinion. Plaintiff further argues regarding implication and insinuation will be revisited when addressing her defamation by implication claim. So there's that here, statement 2, CBS interview, that 41 to 242, I guess. Defendant: but I grew up as an only child, which everyone who grew up around me knows, and I wish I had siblings. Okay, the court addressed this statement once before, concluding that plaintiff could not plausibly disprove defendant's opinion of her own childhood. All right, this time plaintiffs failed to specifically allege falsity and instead attempt to tie in other statement from the interview, stating that in context this statement was denial that Samantha played a part in her life and her upbringing. Okay, so in other words, instead of showing how Meghan is the only child, she didn't prove that. Instead, she tied in other things. I drove her to school, I did this, and then what about the 18 to 19 years later? Okay, so you cannot go into Meghan's brain to see what Meghan saw. All right, so the judge dismissed that and agree with Meghan, and because this is just an opinion. Okay, quote, in determining the basic question of whether certain language is defamatory, the word used are not to be construed or taken in their mildest or most grievous sense, but should be considered as the common mind will understand. There's that here. Okay, quotation omitted. Following this determination, the court can dismiss a claim if it finds that a statement is non-actionable. So there's all of this. I'm skipping these. Finding a statement not subject to empirical proof or an objectively verifiable event to be a protected opinion. Again, context is paramount to this determination. Okay, defendant's statement came in response to a question about her relationship with plaintiff. There's all of that. She replied that she did not really know plaintiff and grew up as an only child. Further, she says that she will have loved to have a sibling. As a reasonable listener will understand it, defendant merely expresses an opinion about her childhood and her relationship with her half-sibling. In other words, Meghan didn't even go into detail about her childhood. She just saying, you know, what she said. Thus, the statement is not objectively verifiable or subject to empirical proof. Okay, so there's all of that. Plaintiff cannot plausibly disprove that defendant feels she grew up as an only child and wish she had sibling, because the statement is not capable of being proved false. Okay, you cannot prove that because that's Meghan's feeling. You cannot disprove her feeling. That's the part that I'm getting here. That's Meghan's feeling. She felt like she was the only child. That's what she felt. So you cannot disprove somebody's feeling. Okay, it is protected from defamation action. New York Post. Okay, so that's another case here. Thus, the court will dismiss the claim, which has not gained any merit since the last motion to dismiss was ruled on. There's all of that. Okay, so she dismissed it again. All right, so there's this here regarding the CBS thing here. The last time I saw her must have been at least 18 to 19 years ago, and before that, 10 years before that. Okay, plaintiff argues that this statement falsely ignores the multitude of phone conversation defendant and plaintiff had enjoyed throughout the years. Okay, defendant urged dismissal of the claim because assuming phone calls occur, that will not be the same as a meeting in person. Documents 74 to 7. Therefore, she argues plaintiff does not. So defendant is Meghan. So Meghan is saying just talking to you over the phone, that doesn't mean much. Okay, therefore she argues plaintiff does not plausibly allege falsity as to the suggestion that the statement implied that plaintiff, which is the half-sister, was a liar and fame seeker. Defendant claimed this is another improper mischaracterization of the transcript. So in other words, Meghan is saying this is not what she was saying. The sister just misinterpreted it. Finally, defendant argues that defamation law is concerned with truth, not generosity, and that she thus had no duty to mention phone calls during the interview. Okay. Plaintiff concedes that this statement is incorrect only as to the amount of time that lapsed between visits. She argues, however, that it is objectively verifiable that the last time plaintiff and defendant met was far more recent than defendant said. Okay. Then plaintiff proceed to connect the statement to others from the interview and argue defamation by implication, which the court will address with the rest of the count too. Okay. Plaintiff must specify what false statement or statement caused her injury. Alright, so Nissan and all of that, that's another case. The element of falsity is only met if the publication is substantially and materially false. Smith versus there's that, another case making reference to. Here, plaintiff has failed to possibly allege that defendant's statement was substantially and materially false, as she must to state a claim. There's another case here. This conclusion follows from a few premises. First, plaintiff admits that the statement alone is unlikely to support a claim, as it is incorrect only as to the amount of the time lapsed between visits. Okay, there's another thing here. Emphasis. Next, plaintiff responds that it is objectively verifiable the last time defendant saw her was far more recently. This conclusion, assertion, and a response omitting when the last meeting was. She's saying all of that, but she didn't give a specific time. When did you meet her? Okay, when was the last time you saw her? This conclusory assertion and response omitting when their last meeting was, what it meant by far more recently. Okay, she didn't give a specific time where Meghan could say, okay, yes, we did meet, or no, we did not meet. So she didn't give a specific time or any further detail. Yeah, or any further detail does not allow the court to possibly infer that defendant's statement was substantially and materially false. Okay. Additionally, defendant is right. Okay, so the court agree with Meghan. The defendant is right that a mistake regarding whether she saw plaintiff 13 or 18 years ago will be protected by the substantial truth doctrine, as the gist of the statement is the same. There's all of that. Dismissing defamatory claim on the ground that the substantial truth or the gist of a statement was the same, regardless of whether the plaintiff was alleged to have bullied dozens of victims or at least one victim. Plaintiff response as follows. So this is what is it? The sister's response. Meghan's argued that 18 years is like 13 years is the wrong point. It should be that 29 years with one visit 29 years ago is a completely different case than 13 years. Oh, what the hell? Whew. No wonder why I skipped some of these. If there was only one visit since Meghan was 6, there was no relationship at all, especially when Meghan also stated that she did not remember Samantha visiting when she was young. The story was entirely false. Okay, regardless of how the parties did their math, I know, I start getting, oh my God. Regardless how the parties did their math, plaintiff did not exactly show her work. That's it. The court agrees with the defendant that the gist of the statement that it has been over a decade since the two last saw each other is the same. Therefore, the statement is protected by the substantial truth doctrine. There's that here. And as such, plaintiff allegation do not allow the court to reasonably infer that this statement is substantially and materially false. Okay, so they agree with Meghan. Moreover, defendant qualify her statement by stating the last time she saw plaintiff must have been at least. Okay, there's the part here. At least. It wasn't a specific time. She said at least. Okay, this is where the opinion, her memory, okay, you can, she's just rounded up at least a certain number of years ago. This language will give a reasonable viewer the impression she was relying on her memory. That's it. Yeah. Will relying on her memory and proving approximation. That's it. Exactly. Rather than drawing from documentary evidence or undisclosed fact to come up with a number. All right. So it was just a rounding. Okay. Finally, plaintiff's argument that this statement was a mixed opinion is without merit. She fails to possibly allege that defendant applied the existence of undisclosed fact on which her statement was based from, there's that here, generic response, that defendant state her opinion based on fact not disclosed. There's doctrine here. I'm saying doctrine. Document 79 to 7. Okay, is of little help to her because the court need not accept such legal conclusion as true. Okay, therefore, as described above, the court cannot draw a reasonable inference that the defendant is liable for the misconduct alleged based on the statement. All right, there's another thing here. Case. Additionally, there is no allegation from which the court can reasonably infer that the defendant made this statement knowing that it was false or with reckless disregard of its potential falsity. As such, plaintiff claim as to this statement will be dismissed. All right, so the court just ignored that because she didn't even give a specific. She said at least based on opinion. The final two statements from the interview are embedded in the following excerpt. Since this is short, I'll read it. Oprah Winfrey. So you all weren't close. You didn't grow up together. Defendant, no. Oprah Winfrey. She doesn't really know you. Defendant, no. She changed her last name back to Markle. And I think, there's an opinion back here. I think she's in her early 50s at that time, only when I started dating Harry. And so I think that says enough. Opinion again. Defendant, which is Meghan, first allegedly defamatory statement consisted of her answering no, okay, to the question of whether she and plaintiff grew up together. Plaintiff claimed that this damaging and hurtful response attacked plaintiff, which is the half-sister, veracity, calling into question on a world stage her own fond memory of the time spent together when they were both young, with their father, Thomas Markle, and his home where she was living at that time. Okay, again, defendant answer and context is clearly her opinion. Again, you see where she said, I think. All right. Again, defendant's answer and context and clearly her opinion of her own childhood and relationship with plaintiff. It is neither objectively verifiable nor subject to empirical proof. Therefore, it cannot support a claim for a defamation and must be dismissed. All right, so there's that here. Plaintiff attempt to explain why this statement was false and fact support this conclusion. They're using her own. They're using her own word, it seemed like. Plaintiff attempt to explain why this statement was false and facts support this conclusion. According to plaintiff, defendant's single word answer called into question. Plaintiff various fond memory, okay, there's that here, memory, emphasize added. They use her own word against her. That's the way that I'm seeing. An occasion or period in time that one person remembers as fond memory may be remembered quite differently by others. And either way, an individual's feeling about the past are not objectively verifiable. Therefore, plaintiff claim as to this statement, which will ultimately have to establish that the two half-sisters grew up together and or were close, falls outside the boundaries of a possible defamation claim. Next, the court considers the second part of the statement regarding plaintiff name change. Plaintiff argued the statement was false and harmful because it was not the time that she began to use the name Markle. There's that here. She asserts that this statement creates an air of mendacity around her and ignore the number of reasons why one might change their name and the unspecified reason defendant in fact did so. Okay, so let me go back again here. She asserted that this statement creates an air of mendacity around her and ignore the number of reasons why one might change their name and the unspecified reason. So in other words, she raised the question, but she didn't give any reason for that. Okay, reason defendant in fact did. Meghan, however, did. Okay, plaintiff also postulates that the second part of the statement, I think that says enough, implies that she was nefariously using defendant's last name to cash in on her sister. Furthermore, plaintiff states that she used the name Markle interchangeably all the time, okay, and legally changed her name back to Markle only 5 years after defendant started dating Prince Harry. Defendants argue for dismissal of this claim based on the materials that have been judicially noticed and the substantial truth doctrine. Okay, she argues that using last names interchangeably will not be substantially more damaging to plaintiff's reputation than changing her name legally for some particular reason. At 8 to 9, plaintiff respond that the statement is not substantially true despite her intermittent use of the name Markle. There's that, document 79 at 5. Okay, she contends that her complaint avers she did not change her name when defendant started to date Prince Harry, which defendant stated as fact. Okay, so the half-sister saying Meghan said she changed her name when she started dating Harry. Okay, so let's see here. Based on the material that have been judicially noticed in this case, this claim must be dismissed based on the substantial truth doctrine. Okay, so Meghan proved that. In addition, the plaintiff's failure to possibly allege actual malice other than in the conclusory manner. So Meghan proved that. As previously explained, a substantially true statement is generally not actionable. There's that here. There's all of that. Because the common law of libel overlooks minor inaccuracies. See also, there's another case here, holding that falsity only exists if the publication is substantially and materially false, not just if it is technically false. The court has taken notice of the fact that the plaintiff used the surname ROSANOVA in September 2016 and Markle 2 months later. Wow. Wow. Soon after defendant's royal relationship was first, like I was saying, Meghan proved it. Wow, there was document in court. Okay, the court has taken notice of the fact that, I'm telling you, there was some stuff I was looking online about her daughters and all of that. I don't know if it was around the dates. I don't remember the dates that were in that, but I remember in PYTE, I read some court documents. I think it was PYTE, where some squaddies were showing some court documents. I don't remember which state it was, but it has to do with her daughter and stuff like that, but I don't remember if it was around this time. But let's continue. Okay. The court has taken notice of the fact that plaintiff used the surname Rasmussen in September 2016 and Markle 2 months later, soon after the defendant, which is Meghan, royal relationship was first reported. Oh my God, this is crazy. So the judge is saying Meghan is right. Wow. Therefore, there's all this information here. Therefore, the gist of a statement that the plaintiff switched to her family name a short time after it was reported defendant was involved with Prince Harry is true. Wow. This is epic. So Meghan was right about that, and the court agrees with her. Moreover, the precise reason for her switch were not specified or suggested by the defendant. Okay, Meghan did not explain all of this. So who merely stated, I think that says enough. Okay, there it is here. Think. Alright, amorphous statement that cannot be objectively verified. Okay, there's that. Oh my lord, this is epic. The claim based on Statement 5 will thus be dismissed. A plaintiff's attempt to plead a viable cause of action may be defeated by her own evidence. By her own evidence. See, let me see this one here. So this is her own evidence. What is that? State environmental. Okay, so never mind about that. Let's go back. I thought I was gonna find the answer right away, but too much to read. Our duty to accept the fact and the complaint as true does not require us to ignore specific factual details of the pleading in favor of general or conclusory allegation. See also, there's all of that. Conclusory allegation and unwarranted deductions of fact are not admitted as true, specifically when such conclusions are contradicted by facts disclosed. Okay, there's facts. In other words, Meghan proved her case. There's documentation of what Meghan have said, and then based on what the half-sister claim, okay, disclosed by a document appended to the complaint. If the appended document to be treated as part of the complaint for all purpose under rule, there's another rule here, reveal fact which foreclose recovery as a matter of law, dismissal is appropriate. So the court dismissed that. The plaintiff used one last name and then the name Markle soon after report of defendant's relationship with Prince Harry were published is substantially true. Wow, based on the exhibits and the record of which the court has taken judicial notice. What? I remember reading some of these things. I don't know if this is what the judge is making reference to, because I remember some squads, I don't know, were putting some court documents about, was it, what southern state? Is this, no, is it Nevada? New Mexico. I think it was New Mexico. That with her daughter and all of that. Okay? But I don't know if it was around 2016. But anyway, so there's concrete evidence the judge have taken into consideration. And the court cannot reasonably infer otherwise. Okay, so there is viable, physical evidence of these things. So the judge have to agree with Meghan. For this reason, the court cannot draw a reasonable inference that the defendant is liable for this statement. Okay? Futility.
It is a great privilege to be with all of you today.
You know, we ask for forgiveness and please come back.
for all my life. You are all in this together, and if I may speak personally, we are all in this together, because asking for help was one of the best decisions that I ever made. You will be continually amazed how life changes for the better